Justice Hedu Gangudi to read her judgment.
So I have considered in detail the majority decision in this consolidated petition, the factual background, the summary of the submissions advanced by the parties, as well as the issues for consideration and determination as framed. I'm in agreement with most of the issues in the majority judgment. These issues are the jurisdiction of this court, res judicata, public participation, enjoyment of the President and the control of budgets, and lastly, the financial budgetary estimates. I, however, differ with the majority on two issues. Namely, one, whether the office of CAS was constitutionally established, and two, whether the 50 CSs were appointed in accordance with the law. The office of the CAS was first established in Kenya on 24th of January 2018 by the former President Uhuru Kenyatta. He subsequently nominated and appointed the CSs alongside the cabinet secretaries and the permanent secretaries. This decision was soon after challenged in the Okiya Omtata case. And on 20th of April 2021, Justice Murima rendered his judgment in which he declared the establishment of the CS office unconstitutional. The orders issued are found at paragraph 309 of the said judgment. A perusal of the fifth respondent's CEO Simon Rotich's response in the ELRC petition number E174 as relied upon by the first respondent in the instant consolidated petition indicates that a while later, on 19th of September 2022, the PSC received a letter from the then head of public service, Mr. Kinyua, informing it of the President's proposal on the establishment of the office of the CS in the public service. In brief, the letter set out the history of the office and the justification for its establishment. Equally, the President proposed that the office of the CAS be ranked in the public service within job group CSG3. Further, that one position be established in each ministry, except in the Ministry of Interior and Coordination of National Government, that would have two positions in light of the scope and significance of its portfolio mandate. The letter as well listed the job description of the CAS and relevant qualifications. Based on this, the fifth respondent at its weekly meeting on 21st of September 2022 discussed the proposal and observed that the office had been established in January 2018. However, the process of establishing it had been declared unconstitutional in the Okiya Omtata case for lack of compliance with provisions of the Constitution. Considering the court's decision in the said case, the fifth respondent resolved to abolish the CAS office established on 24th of January 2018, comply with the orders of the judgment in light of the President's request, and conduct public participation. The fifth respondent via a press advert on its website and the local dailies dated 21st of September 2022 invited members of the public to submit their views on the proposed establishment of the said office. And following the call for the public to issue its views on creation of the office, the second petitioner filed the ELRC petition number E174 of 2022 against the fifth respondent for the reason that the advert was illegal for violation of Section 27(1) of the PSC Act, insofar as it failed to include fundamental details to enable the public make meaningful and informed contributions towards the establishment of the office. Further, that the advert was unconstitutional for violating Article 201(d) of the Constitution, as it seeks to establish an office in the public service with duplicity of roles as that of the Principal Secretary. Justice Mbaru, in the said matter, satisfied that the fifth respondent had complied with the orders issued in the Okiya Omtata case and the dictates of the Constitution held as follows in the judgment dated 16th of February, while dismissing the petition. Upon being satisfied that the creation of the office of CAS is justified, upon being satisfied that the financial implications of creating such office is indicated, and that the office so created relates to or supports the core functions of the public body requesting for its creation, such satisfaction is sufficient for the first respondent. It is its core function under Section 27(1) of the PSC Act, and in this regard, the internal processes for levels for grading, designation, qualifications and remuneration cannot be faulted. The fifth respondent, in its response dated 11th of October 2022 to the President's proposal, informed of the outcome of the public participation exercise, steps taken to comply with Section 27 of the PSC Act, and after making all these considerations, recommended establishment of the office as proposed. Following this conclusion, the office of the CAS was established via a letter dated 11th of October as communicated by Joseph Kinywa, the then head of public service, to the fifth respondent's chairperson, Mr. Mushiri. With this contextual background in mind, it's my considered view that the petitioners in both petitions, that is the Okiya Omtata case and petition number E174 at the ELRC court, were concerned about the legality of the actions of the former and current presidents in establishment of the office of the CAS in light of the dictates of the Constitution. The High Court, as discussed, found that the claim that the processes towards the establishment of the said office was in contravention of the Constitution, as well as sections 27 and 30 of the Public Service Commission Act, which succeeded. The court as such declared the office of the CAS unconstitutional. That is at paragraph 310B of the judgment. This decision in the end formed the basis of abolition of this office and establishment of the new office, whose creation process was affirmed by the ELRC. Appreciating all these factors, this court will now make a determination on this issue as presented by the petitioners and defended by the respondents and interested parties. It is worthy to note and emphasize that the decision in the Okiya Omtata case, as pronounced by Justice Mrima, was stayed by the Court of Appeal. The outcome of the same is a matter that remains unresolved and will inevitably affect the outcome with reference to the office of the CAS in general. On the other hand, the decision in the ELRC petition E174, as determined by Justice Mbaru, was the basis of the fifth respondent's decision to either complete the process of establishing the new office of the CAS or end the same altogether. I say so because from the chronological timelines, it's clear that the fifth respondent did not call for interviews for the CAS position until the ELRC delivered its judgment on the 16th of February 2023. It is further noted that this judgment has not to date been appealed against. Manifestly, the contents of the two decisions arise from courts of concurrent jurisdiction, which legally do not bind this court, as we are of courts of equal status. This was underscored by the Court of Appeal in the case of Bellevue Development Company versus Francis Gikonyo. Be that as it may, this court cannot turn a blind eye to the first and fifth respondents' actions. It is clear that the first and fifth respondents herein, owing to the adduced correspondence before this court, in an attempt to comply with the law and the pronouncement of the High Court, established a new office of the CAS based on the orders issued. This compliance was given the green light by the ELRC in its judgment by Justice Mbaru, which cannot be ignored. This act was in line with PSC's mandate under Article 234, 2A, Roman 1 of the Constitution, which makes known that one of its powers and functions is as follows. The Commission shall, subject to this Constitution and legislation, establish and abolish offices in the public service. My opinion on the preceding point is informed by the Supreme Court observation in the case of Attorney General and 2 others versus D and 17 others. I've cited the portion there. Evidently, the regularization of the office of the CAS as proposed by the President in the letter dated 19th of September 2022 and recommended by the 5th respondent in the letter dated 11th October 2022, being premised on the rule of law, cannot be faulted. The unavoidable conclusion I come to is that the process undertaken to establish the new office of the CS that endorsed 23 posts as seen from the correspondence was lawful. For that reason, the ensuing determination will only speak to the constitutionality of the additional 27 CAS posts. The office of the CAS, as submitted by the parties, was constituted under Article 132 of the Constitution, which essentially spells out the functions of the President. An answer to this question involves interpretation of this sub-article by applying the pertinent principles of constitutional interpretation, which have been dealt with in the majority judgment, but I have referred to the Supreme Court case of Evans, Odhiambo Kidero and 4 others versus Ferdinand Waititu, and the case of Communications Commission of Kenya and 5 others versus Royal Media Services Limited. And guided by the law and opine above, I find one of the facets of a holistic interpretation to be an interrogation of the past. Fundamentally, the question is what informed the description of the functions of the President before the promulgation of the Constitution 2010. I've referred to the final report of the Constitution of Kenya Review Commission, which states that on the attributes of the President, they envisioned and noted the citizens' contributions. With respect to the office of the President, that 1, the President should not be above the law. A majority asserted their concerns were that it should be possible to prosecute him or her for offences while in the office. In this regard, it was also suggested that the Constitution provide for the President's removal for misconduct. 2, the powers of the President should be curtailed. Kenyans felt that the President should not have the exclusive power to appoint senior government officers. It was suggested that for many of the appointments be vetted by Parliament, and that the President should not have the power to determine the election dates. Now, the Commission on this point concluded as follows at page 199. The Presidency, the head of state, must be more than ceremonial. He or she should have reasonable powers. However, those powers should be limited. Excess powers upset the internal balance within the executive, and the principal function of the Presidency would be to symbolize national unity and promote national integration, security of state, and protection of the Constitution. So it's clear from the historical point of view that Kenyans were keen that the President should have limited reasonable power that is exercised within the confines of the law. And turning to the attributes of the fifth respondent, which was categorized under the organs of the government, the committee at paragraph 13.65 under chapter 13 revealed as follows. It is clear that what the people were asking for was the re-establishment of principles of public service neutrality, impartiality, and independence. The people of Kenya want to see appointment processes that are transparent and offices that are not only accountable to the people but also capable of guarding public wealth and resources. So out of this conclusion, one of the first recommendations made by the committee was for the establishment of an independent public service commission. Article 132(4)(a) of the Constitution provides that the President can create an office in the public service in accordance with the recommendation of the fifth respondent. To my mind, the intention of this sub-article was to limit the President's power to create an office in the public service to the extent that the creation must be done in tandem with the fifth respondent's recommendation. The recommendation must basically be guided by the edicts of the Constitution and the law. It is apparent, therefore, that the two conditions as conceived were intended to be inseparable and work in harmony. This, in my view, was the intention of the drafters of the Constitution and the aspirations of the Kenyans. With this background in mind and principles of the constitutional interpretation, the question that crystallizes is whether the additional 27 posts in the office of the CAS were properly constituted in light of the Constitution and the law. To answer this question, I will first examine how a public office under this article is established, and with reference to Article 132(4)(a) of the Constitution, the Public Service Act under Section 30 provides as follows. Recommendation to the President. 1. Where the President under Article 132(4)(a) of the Constitution requests the Commission to recommend the establishment of an office in the public service, the Commission shall act in accordance with the conditions provided for in this part. And then the conditions of establishment of an office in the public service is clearly provided for under Section 27 of the PSC Act. Fundamentally, for an office established under Article 132(4)(a) of the Constitution to be properly constituted, the same must satisfy the threshold set out under Section 27 of the Public Service Commission Act, as read with the provisions of Articles 10 and 232 of the Constitution. The number of persons that can be recommended for this position is not expressly stated in the Constitution or the PSC Act. Similarly, the requirement for approval of the National Assembly for the CS's position is not provided for. What is clear is that any post that is established must comply with the principles of the Constitution and Section 27, as read with Section 30 of the PSC Act. A look at the material before this court reveals that through the affidavit of Felix Koskei, the head of public service, dated 24th of April 2023, that on 23rd of February, the President wrote to the fifth respondent seeking a review of the complement of CAS within the public service to vary from 1 in each ministry to 1 in each state department. On the same day, the fifth respondent CEO, Mr. Rotich, wrote to the PS, Chris Kipto, seeking concurrence on the availability of funds to meet resultant expenditure on the additional posts of 27. The fifth respondent, in response to the President's letter, consented to this variation in its letter dated 27th of February. In the letter, the fifth respondent noted that the consent was based on workload attendant to the role of the CS and National Treasury's confirmation of funds. Following this communication, the President increased the complement of the office with additional posts and asked the fifth respondent to recommend persons to be appointed, which it did. Additionally, in response to a letter dated 18th October and 2 letters dated 10th March 2023 by the 5th respondent, SRC wrote a letter dated 14th March to the 5th respondent advising it on the job valuation, grading, and remuneration and benefit structure for the said position. Soon after, the 2nd to 51st interested parties were nominated on 16th of March and appointed by the President on 23rd of March. From the letter dated 23rd of February 2023, it's discernible that the nature of the office of CAS varied drastically. In the initial letter dated 19th of September 2022, the proposal was for 1 position in each ministry, except in the Ministry of Interior and Coordination, while in the letter dated 23rd of February, the proposal was a review of the complement of CS within the public service to vary from 1 in each ministry to 1 in every state department. This letter introduced a new element in the office that was not accounted for in the previous process that was found to be lawful. Furthermore, despite this vital additional aspect, the 5th respondent went ahead to make a recommendation without seeking further information and justification as required under Section 27 of the Public Service Commission Act. Likewise, the sequence and procedure that led to the establishment of the 27 additional CS posts did not involve adherence to the constitutional principle under Articles 10 and 232 of the Constitution. I therefore find that the manner of establishment of the additional 27 posts in view of Article 132, 4A of the Constitution, Sections 27 and 30 of the Public Service Commission Act, and the necessity of the 5th respondent's recommendation was unconstitutional. On the flip side, I find the establishment of the CAS office in the public service with 23 posts to be constitutional. The orders will be as proposed in the majority judgment.
Thank you very much, Lady Justice Hedy Gungudi. I'll now ask my learned brother, the Honorable Justice